Hello and welcome to Holland Estates. You were listening to number episode 640. I'm Stuart Clark.
And I'm Nicole Chanchi.
Hello, Nicole.
Hey, Stuart.
It's our first time podcasting together. I'm very excited.
Sure is. My first podcast, so I'm super excited.
Well, happy to have you here, and hopefully it goes pretty smoothly. For your first podcast, we have a relatively interesting new case to chat about from the Ontario Court of Appeal, which we hope you listeners out there will enjoy. The case is called Barsosky, State and Wellesley, 2022 ONCA 399, and I'll make sure that the citation is up on our website, our blog, when you access our podcast. But it's an interesting case which deals with the question of an interpretation of a will or surrounding a possible life interest or license to a property to a friend. What was intended and what happens when there's some uncertainty surrounding that. But maybe I'll hand it over to you, Nicole, just to give a very basic background of the facts we're dealing with here.
Yeah, of course. This case is on appeal. So the original decision was from November 30th, 2020, at the Superior Court of Justice. So a quick summary of the facts are as follows. So Diane Barsosky died in June 2017. She and the appellant Robert Wesley were close long-term friends, though they were never romantically involved. So Diane left very generously to Robert in her will, which included a specific legacy of $250,000, and that she directed that Robert be permitted to live in her home during his lifetime. So there was also a $500,000 left in trust for the maintenance of the home in the event that Robert was no longer able or no longer wished to live in the home. The money was to be used for his living expenses, nursing, retirement, home expenses, or his funeral expenses. And any amount remaining after Robert's death was to be delivered to St. Stephen's Community House, so a charity. So after Diane's death, a private investigator retained by St. Stephen's Community House gave evidence that Robert was not living in the home on a full-time basis. So because of this, the charity requested that the home be sold pursuant to the terms of Diane's will. So the estate trustee sought direction from the court, and they ended up in the Superior Court of Justice. So at that point, the application judge determined that Robert was given a license and not a life interest in Diane's home. So the distinguish between the two terms I will distinguish between the two terms, now. So a license is the permission by competent authority to do an act that without permission would be a trespass. So a license with respect to real property, such as Diane's home, is a privilege to go on premises for a certain purpose, but does not operate to confer on or vest in the licensee any title or estate in such property. Versus a life interest, which allows for the right to immediate possession of the property and to its use as the owner. Of course, subject to any restrictions to protect the right of the person entitled to the property at the end of the life interest. So in determining what type of interest Robert was given pursuant to the terms of Diane's will, the application judge placed significant weight on the fact that Robert was Diane's friend and not her partner, and found that the condition that Robert lived in the home was uncertain, and because of the nature of his interest, the entire bequest failed. So on appeal, we have two issues. Number one, whether the application judge erred in finding that the bequest in issue was a license rather than a life interest. And two, whether the condition that the appellant, Robert, live in the house was void for uncertainty. And the appeal was allowed in part. So the Court of Appeal found that Robert's interest in the home was actually a life interest rather than a license. And the limiting conditions subsequent were void for uncertainty. So the gift survived because of that.
Yeah, no, exactly. Thank you, Nicole. Yeah, no, and so the Court of Appeal, goes through all the case law. We won't summarize it for you here, in detail. If you want to read it, you can read the case. But this is a straight up interpretation application, right? It's a question of the court placing themselves in the position of the testator and asking, well, okay, here's a longtime friend of the deceased to whom the deceased clearly intended to give some kind of interest in this property to live in for the rest of their life or to have during their life, but there's some conditions surrounding it. But what did the deceased intend? You're placing them in the shoes, and Nicole mentioned it. It's kind of interesting. At lower court, the court placed great emphasis on the fact that this was a friend relationship. It wasn't a spousal or familial relationship between the deceased and the person to whom she was giving this life interest, license, whatever you want to call it. And the lower court placed emphasis, it appears, on the fact that because they were friends, that somehow it's a lesser gift, right? Clearly, the deceased could not have intended to bestow this more formal life interest because they're friends. It's not a spouse, it's not a kid, it's not a family member. And almost solely on that friendship relationship downgrades the gift from, the more formal life interest to the lesser, if you can call it that, license. And the Court of Appeal, I think quite rightly kind of goes through this and goes, come on, I mean, it's 2022. The familiar relationship, and the relationship you have with friends and the world can be very different. It doesn't have to be that kind of hierarchical, classic family spousal relationship. And you can very easily want to bestow upon, a mere friend, the right to live in your property for the rest of your life, right? Give them a life interest. So I think quite rightly in the decision, the Court of Appeal kind of, picks apart the lower court's reasoning. They're saying, okay, look, if we're placing ourselves in the position of the testator, it's clear she wanted to bestow some kind of interest to her friend here in this property. The fact that they are friends and it's just friendship and it's not a romantic relationship shouldn't, downgrade that relationship or that intention or that bequest. Because I mean, clearly she wanted to bestow something here. And going through all the classic, put yourselves in the position of the testator, stand in their shoes, et cetera, et cetera. The court concludes, and I think rightly, but either way, that it was that clearly they wanted to have some kind of formal life interest relationship here.
Absolutely, and it just goes to show, this is a perfect example of that prevailing, approach to will interpretation, which is, concentrating on the subjective meaning of the words, yes, but also, what are the surrounding circumstances? And here we have somebody who was very, very close to somebody and wanted to gift them, a substantial, portion of their estate. And I think it's said best at paragraph 47, of this decision. The Court of Appeal says, the application judge relied on and arguably contributed to the perpetuation of a now outmoded and exclusionary view of family. So as Stuart, you said, we're in 2022. What families look like now and relationships, it's different. So you can only rely on case law so far nowadays. You can look to the factors, try and meet the test, but at the end of the day, it's what are the surrounding circumstances, and they're always different in these will challenges.
Exactly. So as Nicole alluded to before, the Court of Appeal here, disagreed with the lower court and said it wasn't a license, it was actually a life interest in the property that the deceased had to bestow here. But then in saying that, they acknowledged, look, there are these conditions that surround this now, what we're calling life interest. And there's some uncertainty surrounding those conditions, namely surrounding the language that, if the individual to whom she was giving the life interest was no longer living, in quotes here, at the property, they would lose their right to reside in the property. And of course, as Nicole said here, the charity had hired this private eye, had said, well, he's not there all the time. He's only there sometime. He's sometimes in his other house in another city. Clearly, he's no longer living there, or at least there's questions surrounding it. And the court says, gee, you're right? I mean, what does no longer living there mean? Does that mean he's there? He has to be there all the time? Does that mean he has to be there one day a year? There's some uncertainty surrounding that. And what, if anything, does that uncertainty surrounding that condition do to the life interest here, right? So the Court of Appeal goes through all the tasks and all the cases and says, okay, what happens when there's a condition on a gift that's uncertain? And here, interestingly, this is the difference between conditions precedent and conditions subsequent. The Court of Appeal says, okay, well, it's a condition subsequent here, right? So that you get your life interest, but if, however, you later are no longer living at the property, you lose that interest. And the Court of Appeal goes through the tasks here and says, okay, well, look, typically when a condition subsequent is void for uncertainty, the condition itself is struck from the gift, but the gift's upheld. So if we agree with the lower court here that this condition subsequent, that if you're no longer living in the property, is vague and uncertain and therefore is void, we have the ability just to strike that condition from the gift, and the result would be just giving a life interest in the property to the friend. And that's different and can be distinguished. I mean, this is not a decision, but I know I've dealt with this previously in other files, from a condition precedent, right? Which is a condition that must be met before a gift is made. So if the wording had been opposite, he must be living in the property before I give the property, or something, or he must be residing in Ontario, and if so, then gets property, or something like that. The condition has to be met before you get the bequest. The court has generally said, it's not a hard and fast rule, but it's a general rule here that if a condition precedent is uncertain and void for being uncertain, typically the whole gift fails. So you don't just strike the condition and get the gift outright. The whole gift falls apart and then falls through residue and testacy, whatever it is that falls when that gift falls apart. So here, I think the friend is kind of saved by the fact that it was a condition subsequent, that this, condition was void, you must live in the property, or no longer living in the property was void for uncertainty, because the Court of Appeal agreed with the lower court saying, yeah, we agree. This is an uncertain term. We don't know what is meant here. We can't put our finger right on what has to happen here for you to no longer be living in the property and therefore lose the property. And we agree that it's void for uncertainty, but because it's a condition subsequent, we're just going to strike the gift and give it to the friend outright.
Yeah, absolutely. So it was a good outcome for on appeal for this for the appellant, and really really interesting case, I think, in my opinion, and great, like I said earlier, reminder of the case law can only take us so far sometimes, but it's really subjective and depends on the circumstances. So
I agree. And I think it's a great outcome as well. I think this, the whole point of these interpretation applications is to try to complete what the deceased wanted, right? Put your shoes in put yourself in the shoes of the testator and try to figure out what their intentions were. And it's, I think fairly clear they wanted to bestow something upon this friend. And I think they'd probably be pretty grumpy if they found out that this charity had hired a private eye to try to kick their friend out of the house on some technicality.
absolutely.
So, I think the deceased's intentions are probably being carried out here. The court obviously upheld the gift and wanted to uphold the gift. And, for everyone, probably other than the charity, I think it's a good outcome and everyone's happy.
Agreed. Yeah. Very good. Very, very interesting read. And I think you mentioned earlier, we'll have a link to this, I suppose, on our.
Yeah, we'll link to it on the blog. Again, if anyone wants a citation, it's 2022 ONCA 399, Bersosky Estate in Wellesley. But I think that brings us to the end of our podcast, Nicole.
Yeah,
It's
sure.
been a pleasure.
Yeah, always.
And if anyone has any questions or would like to get in touch with us, please feel free to email us at info@hollandhall.com or leave a comment on our blog page. And until next time, I'm Stuart Clark.
And I'm Nicole Chanchi.
Thank you very much.
Thanks for listening.